It's 9:05 on Tuesday, March 29th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin this morning? Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for the weekly words of wisdom.
Good morning, everyone. Today's weekly words of wisdom are brought to you by Theodore Roosevelt. Believe you can, and you're halfway there.
Well, thank you for that. Mr. Muniz will have to have that was part one. He'll have part two tomorrow when we come back in here tomorrow at 9 a.m. All right, members, if you will, go with me to item number 2, House Bill 2439 by Chairman Farmer. That bill, without objection, will be off notice. Which brings us back to item number 1, House Bill 2524 by Vice Chairman Sexton. Motion. Second. You have a motion and a second. There is an amendment. Do you wish to proceed with the amendment? I believe it's 16181.
No, I think.
You got 2 amendments. Right, I'm sorry. That one was already adopted. We're looking at 16578.
That's correct.
Okay.
Motion on amendment.
You have a motion and a second. You're recognized on your amendment.
Thank you, Mr. Chairman. What this amendment does is it took the concerns that the committee had last week, and we tried to address each and every one of those concerns. We watched the video and talked with legal and told them that we want to make sure that we put everything back in that the committee had concerns about. So that's what this amendment does. I'll be glad to ask any questions or answer any questions anyone might have.
Thank you. Any questions for the member on the amendment? Chairman Curcio.
Thank you, Mr. Chairman, and I want to commend your work. I read through your amendment, and you did exactly, all the questions that were asked last week. I feel like you incorporated those, and so I tried to get down to, when I was looking at this, what are the substantive changes from current law? Once we pass if this bill became law tomorrow, what would the changes be? I think that's really probably the pertinent question to ask, because if all we're doing is we flip it from, we say it's an offense to go armed unless, which is the way the code basically reads now. Instead, we say anybody can carry except. I think that's ultimately what we want to do. You've done that. The one thing, and I'm not saying that this is good, bad, or indifferent. I think this is the public policy debate that this committee should have. So the one thing that would be a change from current law, if this bill were to become law tomorrow, is that right now, if you have a enhanced permit, you can carry in a park with no problem. If you are constitutionally carrying, you cannot carry into that park. Under this bill, that whole section would just be deleted. So that is my understanding, and I don't know if legal had any correction there, but that's my understanding. That's the substantive change from current law. So I think you've done excellent work there, and like I said, if that last piece of it is the public policy debate that we'll have in this committee, and I think that's worthwhile having. So thank you for your work.
Thank you. Representative Sexton, you wish to respond?
Yes, I'd just like to say that I think you covered it exactly. Thank you.
Thank you. Representative Griffey.
Thank you, Mr. Chairman. Thank you for this bill. And maybe this is a question for legal. Would it not also change the legal age for carrying a firearm from 21 to 18? Was that included? So, okay, that's all I have, Mr. Chairman. Thank you.
Are you requesting to hear from Legal Services?
No, thank you, Mr. Chairman.
Okay, thank you. Any other questions for the sponsor on the amendment? Representative Howe.
Thank you, Mr. Chairman. As I understand it, also to the sponsor, it opens up anyone over 18 to carry any type of firearm. Previously, I believe it was just a handgun. Is that correct? Can you clarify that, please? Thank you.
That is correct. Any firearm, not just a handgun, which I think most people, and myself included, thought that way. That was what the current law was. You know, since I was a kid going hunting and everything, I considered both the same. So it does do that as well. Thank you.
Any other questions? Seeing none, we're now voting to adopt Amendment 16578 on the House Bill 2524. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 2524 as amended. Any questions? Questions been called. Any objections? Seeing none, we're voting on sending House Bill 2524 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on. Thank you. Item number 3, House Bill 630 by Representative Gillespie. Without objection, we're going to roll 10 spaces. Let's jump to item number 5, House Bill 2323 by Representative Grills. You are properly recognized. There is an amendment 16564. Is that amendment you wish to proceed with?
Thank you, Mr. Chairman. Yes, sir.
You are recognized on the amendment.
Thank you, Mr. Chairman and committee. Ultimately, what we're trying to do here is decriminalizing the holding of a criminal at gunpoint until law enforcement arrives, as long as the criminal is either directed against the crime is either directed against the person holding the criminal, or a violent crime committed against a third person in that person's presence.
Thank you very much. Any questions for the sponsor on the amendment? Seeing none, we're going to vote now to add Amendment Code 16564 on the House Bill 2323. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We are on the bill as amended. We do have testimony on this bill. So without objection, we'll go out of session. We'll hear from Zoe Sams, if she's here. She's on her way in. You go. Okay, she is good. Jimmy Music. Okay. Patrick Powell. So we're 0 for 3. All right, we're going to go back into session. Oh, excuse me, we're going back out of session. All right. Toby Meyer. Apologize. I apologize for that. I missed you on there. You'll have 4 minutes, if you will, introduce yourself and state your name for the record, and you'll have 4 minutes for testimony.
Thank you, Mr. Chairman. Good morning, everybody. My name is Toby Meyer. I'm with T-Rex Arms. The reason I support this bill is because it tilts the playing field, or shifts the playing field, which is currently tilted in favor of criminals. It shifts it back a little bit more in favor of victims of violent crimes, and make sure that we arrest criminals committing violent crimes and not people who just became a victim of a crime. So currently, under Tennessee law, it is a felony to hold a person at gunpoint until police show up, unless you are currently in immediate fear for your life, serious bodily injury, or serious sexual assault. The problem is whenever there is an adjective such as serious, it leaves you very vulnerable to prosecution and interpretation by the court. And as soon as the threat is no longer immediate, you're no longer justified to even threaten deadly force. So picture the situation: someone just rapes your wife, says with a smirk to you, "What are you going to do about it?" and walks away. That moment, if you hold that person at gunpoint until police show up, you're actually committing aggravated assault with a deadly weapon. even your wife would not be allowed to actually hold that person the moment the person is no longer an immediate threat. If she would, unless she were to be able to actually overpower the person physically. Same, if a murderer runs out of ammunition, for example, at that moment the person no longer poses an immediate threat. So this section actually corrects that and makes sure that police are allowed to arrest the person who just committed the offense, but not the criminal. Also, the amendment makes sure that this only applies in situations where actually the person making the arrest gets personally threatened, or in situations of a violent crime that person has immediately witnessed. So you cannot just look at something in the newspaper and go hunting criminals or something. It's only in those situations where people already believe that they're doing what the law allows them to do. So it brings the law more in line with what people believe to say. I'd like to close with a remark that the Senate sponsor of the bill said that impressed me. God created men and women, but Smith & Wesson made them equal. Thank you.
Thank you very much. Chairman Curcio.
Thank you, Mr. Chairman. And I guess I appreciate the spirit in which you brought those comments, but you left out a whole bunch of facts and a whole bunch of really good laws. If someone's raped my wife, I'm not going to request that I exercise my right to citizens arrest them. I'm going to shoot them in the head. And I'm allowed to do that under current law.
So you are allowed to do that if you catch that person while that person is doing that.
Which is exactly your example.
No, if that person walks away, that moment you're no longer allowed to do anything. So if you catch that person just a second too late, if you want to look it up, TCA section 39.11.621 says you're only allowed to threaten deadly force in the situations where you're also allowed to use deadly force, which is defined in 39.11.611, self-defense, and then incorporates 39.11.612, which is defense of others, which refers back to 39.11.611 for the criteria. And the criteria enumerated in 39.11.611 are immediate threat to your life, immediate threat of serious bodily injury or serious sexual assault. But the moment the threat is no longer immediate, you're no longer justified. Otherwise, there would be no purpose for this bill.
It's fine.
Any other questions for our guest? Seeing none, thank you for your time and being with us today. Yes, we do have a question for legal while we're out of session.
Thank you, Mr. Chairman. Just wondering, if this bill passes, what impact would it have on our current law of stand your ground?
Michelle Fogarty, Legal Services. It would not affect that, but it would allow someone to threaten to use deadly force for any offense committed against that person, such as panhandling, any level of offense. It would allow, if someone was aggressively panhandling you, it would allow you to threaten to use deadly force against them.
Any other questions for legal? Representative Hardaway.
Thank you, sir. Legal, when you say threaten, does that mean display the weapon?
It's my understanding it could be interpreted that way, yes.
So if you don't display the weapon, is that a threat when you merely verbalize it?
It's not defined in statute. That would be up for the court to determine, but it says use or threaten to use deadly force.
Okay, thank you. Maybe one of our other practicing attorneys has an opinion, like Lita Lambert or Curcio.
I didn't know we had so many attorneys on our committee. Leader Lambert's name was called first, and then Chairman Curcio's name was called second. So,
Mr. Chairman, the only thing that I would comment on at this juncture would be the immense amount of construction that is going on I-65. So I apologize for my tardiness.
Chairman Curcio.
Thank you, Mr. Chairman. And I apologize. I was conferring with my partner in traffic, and I didn't hear for what purpose my name was called.
Representative Hardaway, would you like to restate your inquiry?
Yes, sir. In fact, as long as we're on that end, I'll go with Farmer and, well, I'll stop there. The question is whether threatening to use requires you to display the weapon or if the verbal is enough to qualify for threatening to use deadly force.
Chairman Farmer, your name was called. He passes. Okay. Any other questions for legal? Representative Moody.
Thank you, Chairman. And not to get too in the weeds, but just if you can help me with display. So if someone's wearing their weapon on their belt and they just pull their coat back, is that displaying, or is displaying actually pointing the weapon at someone?
I think that would be a question for the fact finder. They could find that to be displaying a weapon.
Thank you.
Thank you. Without objection, we're going to go back into session. We're back on House Bill 2323 as amended. Any questions for our sponsor? Chairman Curcio.
Thank you, Mr. Chairman. And again, I think there's a lot of questions surrounding this. We want to make sure we get it right. I know Representative Hardaway had several questions that maybe didn't have clear answers. But if it would be amenable to you, I'd like to make a motion, send this to summer study.
Second. That is a proper motion. It has been seconded. Any objection by the committee to vote? Seeing none, we're now voting on sending House Bill 2323 on to summer study. All those in favor say aye.
Aye.
Those opposed? No. The ayes prevail. My pen broke. The bill will go on to summer study. Those that want to be recorded as a no, please see the clerk. Representative Grills, you have another bill on the calendar here. House Bill, or item number 53, House Bill 2509. I have a motion and a second. You're recognized on House Bill 2509.
Thank you, Mr. Chairman. Last time we were here about this bill, it was rolled to the Hill pending Senate movement. The Senate has moved the bill, I believe, 7-1 out of the Judiciary Committee. Last week or the week before, not exactly certain, but currently state law prohibits owning an SBR and a shotgun. However, you can own a pistol that has the same function as the short barrel rifle, but it has a different brace on it, making it legal. And in June of this year, ATF is changing the rules, making thousands of Tennessee gun owners double felons overnight. I know we can't necessarily fix the issue, but just trying to take this out of Tennessee law. I'll renew my motion, Mr. Chairman.
Yes, sir. Thank you. I'm sorry. I'm having an ink pen malfunction.
Here, you need an extra?
Well, my handy dandy assistant just retrieved me one, so thank you. The spring flew out of it. Thank you for your explanation. Any questions for the sponsor? Seeing none, we're now voting on sending House Bill 2509 on to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move on to full criminal.
Thank you, Mr. Chairman and Committee.
Also, Representative, before you run away, you have item number 38, which is House Bill 2327. It has not been calendared in the Senate on their last calendar. You wish to take that off notice?
Please.
Okay, without objection, we'll take that off notice. Thank you.
Thank you.
Okay, members, we're back on item number 6, House Bill 2780 by Representative Eldridge. You have a motion and a second. You recognize there is an amendment 16525. Do you wish to proceed with that amendment? Well, actually, that's Chairman Curcio's amendment.
That is correct, yes.
We need a motion and a second on the amendment. All right, you recognize Chairman Curcio.
Thank you, Mr. Chairman, and I appreciate the sponsor. This is a friendly amendment. This was just, I actually passed a bill last year that dealt with fingerprint evidence, and when we saw this bill coming through the system, we realized that it could conflict with that. So what this amendment does is it incorporates all the original language that the representative had, but it also clarifies that the fingerprints will be sent to APHIS so that they can be included in that database.
That's correct.
Thank you.
Thank you. Any questions for the sponsor on the amendment? Do you have any comments you'd like to make on the amendment?
No, it is a friendly amendment.
Okay, thank you. Without objection, we're voting to add Amendment Code 16525 on the House Bill 2780. All those in favor say aye. Those opposed, the ayes prevail. We adopt. We're on House Bill 2780 as amended. You're recognized.
Thank you, Chairman. This bill comes to us from the Tennessee County Officials Association. It would allow county clerks, court clerks, register of deeds, county trustees to offer fingerprinting services in their offices, and it is a permissive bill. If they choose not to, that's entirely up to the county. The service would be performed at a cost to the consumer and not subsidized by the county tax dollars. And the fingerprinting service is limited to those that are required by law for background checks for jobs, including attorneys, healthcare workers, educators, and professionals that require state licensure.
Thank you very much. Members, there is testimony on this bill. Before we do so, is there any questions for the sponsor? Representative Hardaway.
Thank you. Is TBI okay with this?
Yes, they are.
All right. Thank you, sir. Thank you, Chairman.
Thank you. All right. Without objection, we will go out of session. Is a Pamela Moses here? Seeing none, we will go back into session. We're now on House Bill 2780 as amended. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal.
Thank you, Chairman and committee.
Item number 7, House Bill 2619 by Representative Harris will be without objection off notice. Item number 8, House Bill 2563 by Representative Hicks, Gary Hicks. It's not here. We will roll 10 spaces. Item number 9, House Bill 1936 by Chairman Curcio. We'll roll 10 spaces. Members, we'll go back to item number 4, and I'm going to pass the gavel down here. Whoever. Y'all can just, whichever. Go ahead. You go ahead, whatever.
All right, committee members, we're on item number 4 by Chairman Doggett. This is House Bill 2762. Is there a motion? And is there a second? Second. Motion and second. And my understanding, there's an amendment coded 014932. Mr. Chairman, would you like to proceed with that?
Yes, sir. Thank you.
Is there a second? There's a motion and a second on the amendment. Mr. Chairman, can you tell us what the amendment does, please?
The amendment makes the bill, and what we are doing is codifying the current pay scales for assistant district attorneys as well as public defenders conference.
Members, any question on that? Representative Griffey.
Thank you, Mr. Chairman. I'm going to abstain from voting on this due to my wife's employment as an assistant district attorney. So thank you, Mr. Chairman.
Anything additional? All right, we'll be voting on adding amendment coded 014932. excuse me. Yes, sir, go ahead.
Thank you, Mr. Chairman. And to the sponsor, I notice there's no fiscal note on this. Is that correct, or wait, am I looking at the wrong one?
Chairman Doggett?
You would be correct. There is no fiscal note because this is what they're currently doing. We're just codifying in code as their current pay scale.
Okay, I'm just going on record that I wish we were giving them a raise while we were doing this. Thank you.
Second. All right. Any additional questions for Chairman Doggett? All right, seeing none, again, we'll be voting on adding Amendment Code 014932 on to House Bill 2762. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. We're back on House Bill 2762. Any additional conversation? All right, seeing none, we'll be voting on House Bill 2762 going to full criminal. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. Goes to full criminal. Mr. Chairman, while you have passed the gavel down, if we could take up item number 10 on the calendar. This is House Bill 2165. Is there a motion? Motion. Is there a second? Motion and a second. There's amendment coded 016582. Mr. Chairman, do you want to proceed with that amendment? I'll take that as a yes. Is there a motion? Motion. Is there a second? Motion and a second on this. I believe this amendment makes the bill. Any questions on the amendment? If you'd like, since it makes the bill, we can put the amendment on the bill and then take questions. Question on the amendment. All in favor of amendment coded 016582 going on to House Bill 2165 signify by saying aye. Aye. All opposed, nay. The ayes have it. All right, we're back on House Bill 2165. Chairman Doggett, if you could explain to us what the bill does as amended.
If you will, give me 1 second.
Yes, sir, Mr. Chairman. Thank you, Chairman Doggett.
Thank you. This is bills brought by the Department of Corrections, and it allows advance payment for witness testimony in their cases.
Thank you, Mr. Chairman, and I will say this deals with kind of a nuanced issue that has come up when witnesses travel for testimony and indigent defendants on how that is paid for. So I appreciate the department bringing this. We do have several individuals that could testify on this. We have Mr. Tory Grimes from the Department of Correction if anyone would like to hear testimony from him. All right. If we can go out of session, Mr. Grimes, if you can come up, please take a seat there. And with that, members, we're out of session. Please state your name for the record and tell us anything you'd like to about this bill and then take questions.
Good morning, committee, chairman and committee. Tory Grimes, senior counsel, legislative liaison for the Department of Correction. And we appreciate Chairman Doggett and Leader Lambert for bringing this bill. We've worked with the District Attorney's Conference on really trying to clarify an issue that's kind of arisen over the last several months. And, you know, most of our reimbursement statutes for witness reimbursements, when the DA is trying to put on their case, some of those statutes, quite frankly, go back to the 19th century. So the department really has to reconcile over 4 or 5 different code titles. So what this bill does is it really pulls the criminal reimbursement matters all under Title 40, and it allows the department to make an advance payment in those cases or a reimbursement for fees, which could be a victim fee or a witness fee, when that victim has to take part in trial. And really what happens is, in those cases, we will not require a determination of indigency by the court, because, as you know, that now trials sometimes can take a while, can take 6 months, 8 months. So we don't want to create a scenario where the DA needs this witness may not have the means to travel and appear. We want the DA to be able to request those funds on the front end, and then the department's going to maintain a receivable against the final cost bill, which may come later. And I'm thinking those cases in which there's a motion hearing or sentencing happens sometime after, so you won't get that final indigency established so that the state can make that payment. So this is, we feel like this is a good compromise, and hopefully, and again, Chairman, Representative Beck, I don't think it's an issue in Davidson County, because Davidson County, I believe, has a separate fund to handle all of these, and it's all reconciled on the cost bill. But I think this is more for the rural districts that may not have the appropriated funds to really do this. So,
Representative Beck.
Thank you. So we're basically giving you the ability to front the money for the victims' costs.
The statute provided discretion.
Grimes.
I'm sorry, leader. The statute provided discretion on advance payments. So meaning that if this victim or this witness needs to appear, and all of this could be requested on the front end, like 10 days ahead of time, but the situation has arisen that, victim says, I can be there, I'll just get a hotel, or I'll handle the cost up front. But you don't want a scenario where that witness or victim witness has to wait 6 months, 8 months, 10 months to be reimbursed, because there's another section of code, they're entitled to a state travel claim reimbursement for their participation. So we hope this cleans up some of those and helps reconcile those varying code sections. And again, I personally worked with Ms. Zoe Sams at the conference to really try to get this issue resolved. So we hope that this helps resolve it.
Representative Beck.
Very good. Thank you so much.
All right. Any additional questions for Mr. Grimes while we have him here? All right, seeing none. Oh, Representative Hardaway.
Thank you, Chairman. Mr. Grimes, I just want to be clear, because once someone said victim, somebody said witness, you said victim and witness. This is for victim and witness, or does it exclude victims who are not witnessing?
No.
Mr. Grimes.
The statute is witnesses, and encompassed in that term witnesses, it could indeed be a victim witness.
Representative Hardaway.
All right, but not necessarily if a witness just wanted to be there to witness justice, this would not apply.
Mr. Grimes.
No, sir. This has to be when they're needed as part of the prosecution.
Representative Hardaway, anything additional?
No, sir. That settles it for me. I'm assuming, Mr. Chairman, that there's something in statute that addresses that. Otherwise, I'll be looking for your bill next year.
Thank you, sir. All right. Anything additional? No. All right, Mr. Grimes, thank you. I also have Ms. Pamela Moses, who has signed up on several bills today, and I know from time to time chooses not to testify on different ones. Ms. Moses, are you here? All right, we have Ms. Moses on several bills. Maybe she'll join us a little bit later. We're back in session. All right, members, any additional questions for the chairman on this particular piece of legislation? Questions being called on the bill will be voting on sending House Bill 2165 to full criminal justice. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. All right. Chairman Doggett, we're on to item number 11, which is House Bill 1905. And I will say, since you've allowed me the privilege of chairing today, that we all appreciate the fact that you've put your items that you carried on the bottom of the calendar for many weeks in a row on some of these. And, Mr. Chairman, we appreciate that courtesy, the rest of us, because our bills have got to kind of move on while you've waited patiently. So, members, we're going to take up basically everything that Chairman Doggett has, and I apologize to the members that are waiting, but some of these items he's waited many weeks just to be able to present his bill. So, motion on the bill, is there a second? Second. There's a motion and a second, and Chairman Doggett, I don't see any amendments on this bill. If you can, just tell us briefly what it does.
Thank you very much, Mr. Chairman, and this was brought to me by my local task force. Currently, there are several provisions in the code that state if a person comes to a hospital with or goes to a doctor and they have things that have occurred to them, such as, if they've been stabbed or shot or have injuries that have resulted in the use of methamphetamines, that law enforcement and the district attorney's office are notified of these. What we're adding here is overdoses would be added to this list of items that would be that law enforcement and the DA's offices would be notified of. We do have an increasing issue with overdoses due to fentanyl throughout this state, and my district is no different than any other. And so what we're hoping is to help with the prevention and detection of these drugs by notifying law enforcement and the DA's office of such overdoses.
Members, any additional questions? Representative Griffin.
Thank you, Mr. Chairman. Just a question of inquiry. Has anyone signed up to provide testimony on this legislation?
Representative, there is no one signed up for testimony on this particular piece of legislation.
Okay. Thank you, Mr. Chairman. Look, I would just commend Chairman Doggett on this legislation. I want to sign on as a co-sponsor. Folks, if you haven't been paying attention, we're experiencing a drug epidemic in America, and I can't think of anything more important than someone that almost loses their life if we don't do something to get law enforcement in there to help them and help the community, because people aren't doing drugs all by themselves. They're spreading it to the community, to other people, and it's ruining the lives of so many families. So I want to commend Chairman Doggett for bringing this legislation. I'll definitely sign on. Thank you.
Representative Beck.
Thank you, Mr. Chairman. To the sponsor, is there an amendment on this?
I'm going to answer that question. Actually, we had referenced earlier there is no amendment that is proposed at this time. The bill is as written.
To the sponsor, this is a lot more than just overdoses. This is inflicted by means of a knife, pistol, gun, deadly weapon, or other means of violence, suffering from the effects of poison or suffocation, where there's a wound or reasonably believed to have resulted from the effects, resulted from exposure to meth. That's where we get into.
President Beck, I hate to interrupt, and I apologize, but Chairman Doggett is eager to answer that question, and so if I may go to him just very briefly, and then I will come back to you, I promise. Chairman Doggett.
Thank you for that question. What you're reading from is actually current law. We are adding into those by means of a knife, pistol, gun, or other deadly weapon, by means of violence, suffering from the effects of poison or suffocation. We're adding in there the language that states suffering from the effects of poison, suffocation, or drug overdose. We're adding drug overdose into that list of items that they're already being notified of currently.
Representative Beck.
Very good. Thank you.
All right, members, any additional questions for the chairman on this particular piece of legislation?
Question on the bill.
All right, questions been called on the bill. I will say just, I waited to the end. Chairman Doggett, I appreciate you carrying this. This came from some of your local folks that actually had spoken to me about this as well, and it's a very broad problem, so thank you for carrying it. All in favor of sending this to criminal justice full, this is House Bill 1905, signify by saying aye. Aye. All opposed, nay. The ayes have it. All right, members, we're down to item number 37. Take a moment, flip through your calendar there and or on your electronic device. Item number 37, House Bill 1855. There's a motion and a second. Chairman, I see no amendments proposed on this. If you can, just tell us what the bill does.
Thank you very much, Mr. Chairman. We are revising the penalties for continual sexual abuse of a child to clarify that an offense involving 3 or more violations of aggravated rape, aggravated sexual battery, rape of a child, solicitation of sexual abuse of a minor, or aggravated rape of a child is a Class A felony. An offense involving 2 violations would be a Class B felony, and an offense involving 1 or no violations, prior violations, would be a Class C felony.
All right, members, any questions for the chairman on this particular piece of legislation? Seeing none, I'll be voting. Representative Hardaway.
Thank you, Chairman. Would you go over the Class C felony again, the violations?
Chairman Doggett.
Thank you. 1 violation or no prior such violations would be the C felony.
Okay.
Representative Hardaway, additional?
No, sir. I just heard no violations. I didn't hear no previous violations. Thank you.
Yes, sir. Thank you. And any additional questions? All right, seeing none, we're voting on sending House Bill 1855 to full criminal justice. All in favor signify by saying aye. Aye. All opposed, nay. The ayes have it. All right, Mr. Chairman, I think that ends the section of the calendar and the numbers that you have. I will say that Chairman Hicks has joined us, but that is entirely your decision on whether or not to take him up.
Thank you very much. We will go back to Item number 8. Item number 8, House Bill 2563 by Chairman Hicks.
Thank you, Mr. Chairman. Thank you, committee. And House Bill 2563 is a bill that was brought to me, to be honest with you, through back in my district. This past summer, my juvenile judge, along with some of my principals, told me about an issue they were having in their school system. And keep in mind, the principals that I spoke with were actually middle school principals. And so I'm talking grades 6th through 8th. And the issue they were having was with vaping. The issue was they were having kids and we're having students that show up with vaping. And really right now my juvenile judge came to me and said, I don't have any teeth to be able to hold these children accountable. Right now it's basically a civil penalty. And quite frankly, they're just basically just turning their head at a civil penalty. And so what I was wanting to do was try to find a way, and this is not as much about, it's about vaping, make no mistake about it. But it's a matter of time, and we see it across the country, we see it in our state already, but it's a matter of time for some of these kids are going to get a hold of something that's bad in these vapes. And so that's my concern. It's not as much, if it was just a straight up vape, while I think it's bad, it's wrong, and I certainly don't think it's good for them, you know, that's one thing, but the fact that they're going to get a hold of something that's going to kill them, that's what absolutely scares me to death as a school administrator, and it should keep us up at night as legislators as well. I was hoping that I would have a good bill before you to be able to bring to you and say, here is a solution to a problem that we have, but quite frankly, we're just not there yet. And so my request would be that this bill would be sent to a legit summer study so that we can look at this and determine and get all stakeholders, everyone that wants to be included in this, and have a conversation and come back with a good solution next session. And hopefully I'll be here to be able to bring it forward. So that would be my request.
Thank you. Leader Lambert.
Thank you, Mr. Chairman. Mr. Chairman, I was fine with the bill as written. I know you and I have talked about this for several months, and you valiantly tried to just make sure that you are protecting the children of your community and make sure they at least understand some of the dangers of some of these products out there. We'll have some testimony, I'm sure, later on what all can go into a vape pen. And it's almost unlimited as to different type of substances that can go into that. And so I appreciate your drive for summer study. I mean, if that's what you want, we'll be happy to do that, I think. But I just wanted to tell you, I mean, I thought your bill was good as written, and you're doing really good work here. So I know you're trying to be respectful of everybody else in the process. I did want to note to all of those members that are here, we have been very kind, Mr. Chairman, and we would all just ask as a committee is when we're in your committee down the hall, if you could be equally as kind to all of us, we would genuinely appreciate it. So with that, Mr. Chairman, I would make a motion for summer study.
Thank you.
That's a proper motion. It has been seconded. Okay. We're now voting on the summer study motion. Sorry. Hardaway, Representative Hardaway.
Yes, sir. I just wanted to amend that motion to make it contingent upon the chairman's behavior in the committee down the hall.
Okay. Thank you. The motion here is, and has been seconded, is to send House Bill 2563 to a summer study. Any objection? Seeing none, we're now voting on sending House Bill 2563 on to summer study. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. It goes to a summer study.
Thank you all.
Thank you. Item number 12, House Bill 2860 by Representative Kumar.
Thank you, Mr. Chairman and committee.
There is an amendment 15489 that is traveling here. Do you wish to proceed with that amendment?
Yes.
You have a motion and second. You're recognized on your amendment.
Thank you, Mr. Chairman. If you will kindly attach the amendment and I can explain the amended bill.
Okay, question's been called on the amendment. Any objections? Seeing none. We're voting to attach Amendment Code 15489 on House Bill 2860. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We're on the bill as amended. Now, please explain your bill.
Thank you, Mr. Chairman. Under present law, it is a Class A misdemeanor at this time if a dog is left restrained in a manner that causes bodily injury to the animal. My friends, we know that pain and suffering do happen without obvious injury. House Bill 2860, as amended, provides that a warning that there is a warning for first offense and a Class C misdemeanor for second and subsequent offense for circumstances of restraints in harsh environment when a bodily injury to the animal is not apparent. And those harsh circumstances include impending bad weather, weather emergency declared by the National Weather Service, as well as when there is a mandatory or voluntary evacuation in progress. This is just extreme circumstances. It's unfair. It's not proper to leave a dog restrained on a leash, tether, or by other means. These are, again, mankind's best friends, and we should have love and care for them.
Well, thank you. Any questions for the sponsor? We do have some here to testify today, but any questions for the sponsor before we go out of session? All right, we are going to go out of session. First on our list is Angela Shubert.
Thank you.
If you would state your name and for the record, and you will have 4 minutes for testimony.
Angela Schubert from Morris Chapel, Tennessee. On a beautiful cloudy day, you check to see that your tethered dog's water buckets are full, and you go to your job as a security guard. You come home to find your dogs are missing, and a citation is taped to your front door. Your dogs have been confiscated. You rush to animal control, and that you're told that your county was briefly under a tornado watch, even though not a drop of rain fell at your home. And under this new recent law, you've committed animal cruelty for tethering your dogs outdoor during a weather advisory. You try to explain that your dogs have a sturdy weatherproof dog house and sleeps inside at night. You beg to bring them home. You're told that your court date is in 4 weeks, and you're advised that if you do not pay the $1,325 to the court within the next 72 hours, the ownership of your dogs will be forfeited for failure to pay advance cost of care. 4 weeks later, you appear in court, and you're told your case has been continued, and you owe another $1,325 payable within 72 hours. You're still not allowed to see your dogs. Another 4 weeks later, you're convicted of animal cruelty, you pay another significant fine, and you're never allowed to own a pet again. Your happy, healthy dogs never return home. The courts award them to the impounding agency, and they're sold to other families. Your indoor cat and parakeet are also confiscated on the day of your conviction. Your 14-year-old cat is euthanized after 5 days, and your parakeet dies at the shelter. One of your former dogs escapes from the fence of the new owner's home and is killed by a car. Your children are devastated. Because of the animal cruelty conviction, you're on the animal abuse registry. You are now prohibited from working around animals or children. Consequently, you're restricted to a desk job at work, demoted, and your salary is reduced. All of this happens because your dogs were outside on a safe tether during a weather advisory, even when no animal was harmed. Think this can't happen to you? Most Tennessee residents are unaware of the current language of 3914-210 that gives members of 850 tax-free rescues arresting powers and the legal right to take your property. These rescue members are private citizens without an ounce of mandated law enforcement or animal husbandry training. They are also given immunity from accountability for missing or injured animals upon a not guilty verdict. There's another alarming fact. If your pet is confiscated and you cannot afford to pay in advance, each month for cost of care, you lose ownership of your pets forever before your case even goes to trial. Even if you can afford to pay the thousands of dollars, you must pay money in advance every month for each day your pet remains impounded, and you do not get that money back even if the charges against you are dropped and you're not found not guilty. Often the organizations that lobbies for these laws are the same organizations that impound your pet and ask for the trial to be delayed. As they continue to be awarded thousands of dollars you must pay for your pet's cost of care. Section B of this bill would make a person a felon and they would be stripped of voting and gun rights if they had 2 tethered dogs that were seriously injured or killed during the act of nature, such as a flood or tornado. Mandating that animals are prioritized over humans during a natural disaster is a disgrace to humanity at a core level. Tragedies happen. Citizens should not fear criminal prosecution after losing their home, their livelihood, and their pets. This is nothing more than an attempt to make criminals out of law-abiding citizens while exploiting their personal property during a real or projected tragedy. I ask that you oppose HB 2860 as no human would intentionally, with malice, harm their animals during an act of God. However, a human life is more precious to preserve during a crisis.
Thank you for your time and your comments. Members, do we have any questions for our guest? Seeing none, thank you for your time. Next on our list, Janet Testerman. You're good? Okay. All right, we will go back into session. We're back on House Bill 2860 as amended. Any questions for the sponsor of this bill? Seeing none, we're now voting to send House Bill 2860 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. The bill moves forward. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman and committee.
Next item we have on our calendar, number 13, House Bill 1214 by Representative Ramsey. Motion.
Thank you, Mr. Chairman, ladies and gentlemen. I appreciate that. This bill does have an amendment with it.
Okay, which one do you have two listed?
16556, I think, is the latest one we had taken with corroboration from the members of the committee.
You are recognized on your amendment.
Thank you, sir. And let me first reiterate current law, which was the original focus of this bill. It's changed with the amendment. Tennessee Code Title 39 was passed in 1994, and it says that an individual who knows they are HIV positive and have hepatitis B or C can be charged with a Class C felony if they engage in intimate contact, donate blood, tissue, or organs, or exchange needles without first disclosing that status. Being convicted of felony has very serious consequences, of course. It can be hard to obtain or keep a job, may impact voting rights, limits opportunities for securing housing and travel. These laws don't require transmission of the disease. They do not draw a distinction between intentional harm, consequential relationships, or protective measures that may have taken the person has taken to prevent transmission, which are accessible. They don't reflect the years of HIV research or significant biomedical advances, which we have now with treatment successes. And worst of all, they negatively impact the willingness of individuals to get tested and be aware of their status. What this amendment does with the bill, it keeps in place what I've just described to you as the current felony penalty for criminal exposure to HIV. However, it eliminates the requirement that an offender be listed on the Violent Sexual Offender Registry and includes a process where those previously convicted will be able to apply for removal of that listing. Just briefly, the Sexual Offender Registry was required in 1996 by the Federal Bureau of Investigation in an effort to require states to develop their own laws and registry to protect specifically children. The focus of the issue and the measures was sexual offenses against minors, sexual violent acts, and predatory sexual actions. The purpose of this monitoring was and is to prevent offenders from causing further harm. Over the past 20 years, even though this was intended to be a federal registry, the information about sexual convictions are now in the hands of the public and have created several additional and serious consequences. Not all registered offenders are actually guilty, and some are guilty of the minor offenses, and yet they have to endure the same consequences as rapists and child molesters. And in some of the states, these vary state by state, but in some of the states, public urination can get you on the SOR. So with that explanation and pending any questions, I would ask you to vote for this amendment, which keeps in place the felony penalties, however, eliminates the requirement for these people, these convictions, to be placed on the sexual offender registry. So I'd ask you to vote for the amendment that makes the bill.
Thank you, Representative. On my list for the sponsor is Representative Griffey.
Thank you, Mr. Chairman, and thank you, Chairman, for just bringing this bill, but I am just 100% against it. To me, this bill is placing the interest of someone who, for their own sexual gratification, refuses to disclose to an intimate partner of a serious health condition that they have, that they may give to this person if they engage in sexual activity with this person. And you're more concerned about what happens to that person, about getting a job down the road. What about the victim who has to go for testing, all the stress and trauma it might cause that victim? Do I have AIDS? Do I have HIV? Am I going to have to go to a doctor? Am I going to have to, take drugs for the rest of my life? I'm sorry, I'm fully against this bill as amended. Thank you.
Response?
And yes, Mr. Chairman, and that was the focus of the original bill, was to share these laws were made 30 years ago, and we everything kind of hinged and being in dentistry, I understand the terror that came through our medical community when AIDS was first developed. I think the first case was 1968, and I had diagnosed several people in my dental practice, and we were in huge fear. But things have changed dramatically. Now the AMA and the CDC have what they call undetectable, untransmissible. And so, as I said before, this felony conviction is still in place. But what we wanted to do was take into account the fact that the perpetrator had made efforts to become undetectable, untransmissible, which is within the reality of treatment now. So understanding you're concerned about the felony conviction and the fact that you wanted to keep it in place, we amended the bill to just do this one part. And I will, actually the registry has 3 different levels. It's a tier system, and the offenses in Tier 1 are sexual battery, voyeurism, indecent behavior with juveniles, obscenity through solicitation of a minor, intentional exposure to HIV, stalking of a victim under 18 years of age. Tier 2, which you have to remain on the registry for 25 years. Tier 1 is 15 years. This is 25 years. Sexual battery of a minor under 18 years of age, pornography involving juveniles, molestation of a juvenile or a person with physical or mental disability, enticing a minor into practicing prostitution, soliciting a prostitution for someone under 18 years of age. Tier 3 is sexual battery, molestation of a juvenile or person, murder, forcible rape, aggravated rape. These are things that need to stay in place, but these are things that don't apply to the Class C felony that I've described. And it not only causes significant disruption, but you have to understand that in situations, and we've had testimony offered to us in situations where there's children in a family and the spouses decide that they're going to split, the spouse that knows the health status of the other partner can deny them access to their children. They can say at any point that they were not informed, and we've seen issues where just huge amounts of rights are taken away, and that offense doesn't really appear in the original federal guidelines or federal focus, which was brought to us for this registry. So, I'm just appealing the idea that that this is overreaction. Scientific changes have been made. You can become untransmissible with little effort, and the CDC and the AMA have as much reflected that in their studies.
Thank you, Representative Griffey.
Thank you. But Representative, what this bill would do is that someone that knowingly has HIV and exposes an intimate partner to that and didn't tell them beforehand, and my guess is by far the vast majority of cases not where somebody didn't contract it, but where somebody actually contracted it based upon that sexual or intimate contact. And what you're going to do is allow that person to hide that from future victims by coming off the sexual registry. And I'm sorry, I just can't support that.
No, as
Chairman Ramsey.
And as I say, the felony conviction is still in place.
Brief follow-up, Representative.
But you're going to take them off the sexual offender registry so future victims couldn't look them up and see if this person did that or not.
That, sir, is the purpose of the amendment.
All right, thank you. Leader Lamberth.
Mr. Chairman, thank you for amending the bill and bringing a different amendment. The original version, I had similar concerns to Representative Griffey. I mean, you know, the C felony, to me, just in my opinion, is appropriate if you're exposing someone to HIV, because an aggravated assault is a C felony as well, where you're either causing or threatening to cause serious bodily injury on someone. And so those two offenses are similar. I think from just a policy standpoint, and I think this is what you or I, anyone would want, is that if you have this particular disease and you're doing your treatments and everything else, just be honest with folks about it. You know, I mean, there's no reason to hide that, not in this day and age. It's not even anybody else's business, but if you're going to engage in a sexual act with another person, then that needs to be knowingly entered into by both parties. That doesn't need to be something where there's any information that's hidden. And that is... It's just something that I feel very strongly about. I know you and others do as well, and share that belief that that's just something where both parties should be very honest and open with each other as to whatever is going on in their lives, and be very, I think, hesitant to engage in that type of activity without full disclosure of anything that might be a risk to one another. So with that, I mean, I do think that having someone on the sex offender registry after that is probably not necessary. And, you know, the criminal penalties, I think, are appropriate. But the sex offender registry really is reserved for some of the absolute worst of the worst of those child molesters and rapists and others that are a danger to everyone in their community. These folks really are a danger to anyone that might have an intimate relationship with them. And medications can reduce that danger. But again, full disclosure is, I think, all we ask from a policy standpoint is just make sure everyone knows all information that might be needed for them to make a conscious decision as to whether or not to engage in that behavior. So I won't go on any more about that, but Mr. Chairman, I did want to say just thank you for bringing in Amendment Coded 016556. I think it makes it a much better bill. Thank you.
Thank you, Representative Beck.
Thank you, Mr. Chairman. To the sponsor, I want to thank you for bringing this bill. What is, with HIV therapy, people can become, as you said, undetectable, and they cannot pass it on through intercourse. We have children who are born HIV positive, and to say that anytime that they have sexual intercourse in their life, that the other person could come back and say, "You didn't tell me." Well, even if they did tell them, it's a false claim. You've got to be arrested. The DA presses charges, and here we go. Your bill is trying to avoid ruining people's lives who are doing the right thing, who are on their therapies, and who are trying to stay out of these situations. And these situations can happen even if you gave the other person notice. As the example that you just gave, you know, revenge in a breakup of a relationship. Sometimes we see it all the time. Can be very vengeful, and especially in a situation where the one of the partners has HIV, and the other partner can hold that over their head for a lifetime, that they didn't, you know, give them notice, and it's a he said, she said, whether actual notice was given. So I appreciate you watching after people who need our help, and as the leader just said, the registry was for the worst of the worst, and this should not, these people who are trying to do the right thing should not be on the registry, and I appreciate your bill. Thank you.
Thank you, Representative Russell.
Thank you, Mr. Chairman. And Chairman Ramsey, when you look somebody up on the sex offender registry, does it say that they're a sex offender, or does it specifically say what they done to get on the sex offender registry?
And some of you with legal expertise may know better than I do, but my understanding is that it gives the offense and tells that they are on the registry, and it's public knowledge. So that's my understanding, unless anybody has any different.
I guess my question would be is if we're looking to eliminate this information to be on the sex offender registry, we should ask ourselves if this is already specifically defined when you look somebody up. So I guess if legal could answer that question, that would be good.
All right, without objection, we'll go out of session to hear from Legal Services.
Michelle Fogarty, Legal Services. It does list the offense for which the person has been convicted.
Thank you. That's all I have.
Any other members have questions for Legal Services? I do have a question for you while we're out of session. What is the offense of criminal exposure to another?
Under 3913-109, a person commits the offense of criminal exposure of another to HIV, hepatitis B, or hepatitis C when the person, knowing that they are infected with one of those diseases, they knowingly engage in intimate contact with another, they transfer, donate, or provide blood, tissue, bodily fluids, organs, or other potentially infectious bodily fluids or parts for transfusion, transplantation, insemination, or other administration in any manner that presents a significant risk of HIV, hepatitis B, or hepatitis C transmission, or they dispense, deliver, exchange, sell, or in any other way transfer to another any non-sterile intravenous or intramuscular drug paraphernalia. So it can be committed in any of those manners.
Does it have to be done without the knowledge of a second party, or is that?
It just says the person has to know that they are infected with HIV, hepatitis B, or hepatitis C.
Okay. Thank you very much.
It is an affirmative defense. If the person knows they are infected, they engage in that behavior, like, for instance, they engage in intimate contact, and the other person knows that they are infected and consents.
Okay.
That's an affirmative defense.
Thank you. Representative Griffey.
Thank you,
for
Mr.
legal.
Chair. For legal, or since we're out of session, TBI's here. If you go to the Tennessee Sexual Offense Registry, it does list the offense of the person's convicted of. So if that answers Chairman Russell's question, thank you.
I got one. Thank you. All right. Any other questions for Legal Services while we're out of session? All right, we'll go back into session. We're on the amendment 16556. Any other questions for the sponsor or comments on the amendment? Seeing none, we're now voting to adopt Amendment 16556 on the House Bill 1214. All those in favor say aye. Aye. Those opposed? No. The ayes prevail. You adopt. We're on House Bill 1214. As amended, I do have, does the amendment make the bill?
It does, sir.
Okay. I do have testimony for this bill, so we will go out of session to hear from Amna Osman. You will, if you will, state your name for the record. You'll have 4 minutes for your comments.
Thank you. Good morning. Thank you, Chairman and members of the committee. My name is Amna Osman, CEO of Nashville Cares, the largest HIV organization in the state of Tennessee, serving people living with HIV and those at risk. I have been a public health administrator for the past 25 years. I have worked solely in HIV, sexually transmitted infections, health disparities reduction, and minority health. I have worked on AIDS research, policy, and strategies to end the HIV epidemic, locally, statewide, nationally, and internationally. HIV today is a medical, manageable condition. Advances in medicine and science have demonstrated that a person living with HIV on effective treatment can have a near normal life expectancy. HIV can be transmitted in 3 ways: blood and blood products, intimate sexual contact, and vertical transmission, which is mother to child, during pregnancy, delivery, or breastfeeding. We have been very successful in the United States to reduce mother-to-child transmission to nearly 0. HIV cannot be transmitted through saliva and urine. We know that HIV medications have proven to be highly effective and significantly reduce the virus in the body of a person living with HIV. These levels are so low, which means a person is virally suppressed or undetectable, has an undetectable viral load, which means they cannot pass the virus to another person. In public health, we term this as undetectable equals untransmittable. Prevention strategies are also available today, which include medications people who are negative can take, and this means that they cannot get HIV or acquire it. There are pre-exposure prophylaxis and post-exposure prophylaxis. The Center for Disease Control and Prevention has deemed these prevention options as effective and a great strategy to reduce the risk of HIV among individuals who are negative. Almost every type of HIV-related discrimination and associated stigma is rooted in gross misperceptions about HIV and their routes and the current realities of transmission and treatment. We've made extraordinary progress in making sure that people are living with HIV and are undetectable. Yet the public understanding of HIV seems really stuck in the 1980s, before HIV was a manageable chronic condition. The current law in Tennessee does not align with the advancement in medicine and science as it relates to HIV today. These laws also affect many people who are taking medication each and every day. I have been working in HIV for 25 years. We have seen great advances in medicine. People today, majority, are undetectable. They are doing what they need to do to reduce the transmission of HIV and to keep the public safe. People who are intimate usually disclose their HIV status. Mostly people don't want to transmit HIV who are living with it. So I really hope that you can take a look at this amendment to get people off the sex registry, because it really truly affects the lives of people living with HIV who are mostly undetectable, and really does not allow them to live, life with dignity and respect and be able to access all of the needs that people need as citizens of this country and this state. So I hope you can consider that and understand that people living with HIV are doing their best to not transmit HIV. I thank you.
Thank you for your time and your comments. Members, any questions for our guest, Representative Griffey?
Thank you, Mr. Chairman. Thank you, ma'am, for being here. Here's my question. If you have a daughter or niece or somebody like that and they're becoming romantically involved with someone, would you want them to have their partner disclose beforehand, before they engaged in sexual activity with their partner? Or would you just say, it doesn't matter, don't worry about it?
Yes, Representative Griffey, I think it's important that somebody living with HIV chooses to disclose, and mostly most folks do disclose. But HIV, what I'm trying to really explain is that HIV has become a manageable illness. It's like diabetes, it's like hypertension. I understand that people acquired it through sexual contact, but people are really trying to do right and live their life, and everybody deserves to have a partner and to be able to live their life with dignity and respect. So yes, I would hope that my daughter or son would have somebody that cares about them enough to disclose, and most people living with HIV do disclose.
Thank you, Mr. Chairman. So I think you've answered my question and my concern. So if your daughter became involved with someone and they failed to disclose that they were HIV positive, then your daughter comes down with HIV positive. Wouldn't you want other people to know that this person, has failed to disclose that he was HIV positive and is infecting other people? Do you think the rest of the public has a concern, and a legitimate concern, that they want to know of people who are violating the law and failing to disclose it to other future potential victims?
Response.
Thank you, Representative Griffey. So I think the law as it stands does not talk about an individual living with HIV transmitting HIV. It is a disclosure law. So it means that I need to disclose. It does not say you will be convicted or prosecuted if you transmit HIV. So I think there's a real difference here that I think sometimes we get confused. Disclosure. And what I'm saying to you is a person living with HIV that has an undetectable viral load cannot transmit HIV at all. And so therefore, if an individual who is in a relationship, and this is the issue with the law as it stands right now, people live in fear. We know that domestic and sexual violence happens all the time in the United States and in Tennessee. If you are living with HIV and your partner is exerting power and control over you, you will always live in fear that you're in a relationship, that you can't have a trusting relationship. Your fear that somebody might use that against you and you will be convicted and be on a sex registry for life. I think that's really important to understand. Yes, advancements in medicine and science, and if we were back in the 90s, we would say, yes, HIV at that time was a serious disease, but we have done so much in advancement in medicine that people now are living a normal life and normal life expectancy, and I think everybody deserves to live with dignity and respect.
Representative Griffey.
Thank you. There's no confusion to me in the law. What this bill would do is protect the lawbreaker who expose somebody else to HIV without disclosing it. And what you're going to do is allow them to hide that from future potential victim if this bill is passed. And I'm more worried about those people than I am the person with HIV. And the person with HIV, all they have to do is disclose it. And if you're worried about somebody coming back and using it against them after the fact, send a text, send an email. Hey, baby, I love you. I'm so glad we're at that point in our relationship where I can disclose to you that I have HIV and you still love me and care about me. There's ways to document that and address this, not the way this bill. This bill is going to expose potential future Tennesseans to HIV unnecessarily. Thank you, Mr. Chairman.
Thank you. Any other questions for our guest? Representative Hardaway.
Thank you, Chairman, and good morning to our guests.
Good morning, Representative Hardaway.
And first, to qualify myself, my experience with HIV goes all the way back to the 70s. My mom had an operation, and I was the only one that was trusted enough that matched her blood type that could give her the transfusions at that time. And as you know, the ability to screen blood was nothing compared to today's science. So my questions are merely for informational purposes. On the level of infection or the viral load, is that directly tied to faithful adherence of the drug therapy? In other words, if you don't adhere to the drug therapy, will your viral load increase?
Thank you. So yes, people living with HIV today take one pill, which has, it's great. We've transitioned from the pill burden. People used to take 10 to 15 pills a day. We're down to one. So that really shows the advancement of medicine. And yes, if you do not take your pill, you can see viral load coming up. And so how we know individuals are undetectable or adherent to their HIV regimen is by how much virus is in their body. So when we say you're undetectable, it means the virus in your body is extremely low for you to be able to transmit HIV, thus you are adherent, yes.
And under this bill, and this might be something that the sponsor or perhaps even legal, Mr. Chairman, would be better suited to respond to. Under this bill, if you fail to adhere to your drug therapy and your viral load increase to a level to where you are infectious, under the amended bill, would you still be criminally liable?
Yes, sir.
Mr. Chairman, yes, the original bill tried to introduce a defense that you made every effort not to be transmissible. That portion of the bill is gone. This only says that what we feel like today is that when you're put on the sexual offender registry, your life's over. And the Tier 3, Tier 1 is 15-year registry, Tier 2 is 25-year registry, Tier 3 is lifetime. And if you ever serve over a year for a sexual offense, you're put on the registry, on the lifetime registry. So that portion of defense is gone. So yes, you still, if you're found by intent to have done this and risk, it doesn't have anything to do with the fact that you actually give somebody something. It's the exposure to. So if you go to court and nobody got sick, you're still liable for this Class C felony. Does that answer your question?
Well, it comes close, and I'll figure it out from here. But
Representative,
thank you,
do you
sir.
want to ask Legal Services that question?
Mm-hmm.
Yes, sir.
Okay.
Michelle Fogarty, Legal Services. All this bill as amended does is it takes this offense of criminal exposure of another to HIV off of the sex offender, off of persons convicted of it will no longer be required to register as a sex offender, and persons who are currently registered as a sex offender based on a conviction of this offense will be able to apply to the TBI to be removed from the sex offender registry. It does not make any changes to the actual offense.
Okay, so my question is not relevant to the amendments and its effect on policy. That's not going to change.
It makes no changes to the actual criminal offense.
All right. Thank you. Thank you, sponsor.
Thank you. Leader Lamberth.
Just one brief question, ma'am. Thank you for your testimony today. I appreciate it. On the bill as amended that takes folks off the sex offender registry, I know I've already stated, sponsoring publicly, that I'm in favor of that change. But I did want to hear you out a little bit more on, I mean, the treatments that folks take for HIV. Mm-hmm. Do they reduce the risk to 0% of transmission?
It's not 100%. It's in the 90s, so yes. But it is, the virus is so low that they have not found individuals who are adherent to HIV, who had HIV regimens are transmitting HIV. And so the CDC, that's why we really, as an organization like Nashville Cares, we work with people to make sure that we can support and provide access and retention in medical care, and also adherence to medications and access to medication.
And, Mr. Chairman, if I may, and that's 90% if they're following the regimen, it's working well, I mean, everything's going fine, it can definitely be lower than that percentage, right?
So people, what we do know based on the medicine, people who are adherent to HIV medication have viral loads that are so low that they cannot transmit HIV to another individual, based on the Center for Disease Control and Prevention, yes.
Yes, ma'am, I understand that.
Yeah.
If they're adherent to it. And here's really my question.
If they are adherent, correct.
Yes, ma'am. And here's really my question. And I listened, and I missed the very first part of what you're saying, but I read some of the stuff that was submitted. Why not have, in this of most intimate relationships that two people could have with each other, which I won't even go there with the fact that, I mean, the dangers of living a promiscuous lifestyle in general. I mean, there are lots of different diseases that can be transmitted. But in a very intimate relationship with two different people, what is the harm in making sure in the law that there is full disclosure so that it is truly a consensual relationship? I mean, I understand what you're advocating for. What's the harm in that? Because to me, it should be a fully consensual decision on both parties to engage in that type of activity. And if not, then one person, the person who does not have HIV yet, is not given the opportunity to fully consent because they don't know all the facts. I'd just like to hear a little bit more of your opinion on why we would encourage folks not to disclose. Because if we take it, even taking it off the sex offender registry, goes a little bit down that road. So I'd like to hear a little more about your opinion on that, if you don't mind.
So thank you for that question, Representative Lambert. So what I will say is people living with HIV want to disclose and usually do disclose because they know that they are taking medication and adherent and they cannot pass the virus. I don't think I've met anybody in my 25 years living with HIV that has not wanted to disclose to their intimate partner, because they know that they cannot transmit HIV. But there is fears about this law, and I'm going to be very honest with you, for people that don't want to get tested, because if you don't know your status, this law does not apply to you. So there is 1 in 7 people who do not know their HIV status in the state of Tennessee, and that is concerning because we're about promoting testing so you know your status. We want to make sure that people are linked to care. And so it's really important for all of you to know, and even the public, that people living with HIV are not out there to transmit HIV intentionally. They truly disclose. We've heard many, many stories about individuals who've disclosed, and they've been questioned, that the courts questioned whether they were disclosing. It's he said, she said. It's really hard. I heard what Representative Griffey said, send a text. I mean, you're trying to have a relationship with somebody, and I think when you get to that point, to the point of disclosure, we should be very honest and have a trusting relationship with each other. But sometimes having HIV and this law affects people living and being able to have, as you said, a wonderful, healthy relationship. Because if you get mad at me and call and say, Amna did not disclose, I'm going to have to prove, even if I verbally disclosed to you or told you multiple times, or if you were aware, or if we broke up and had a relationship where we have separated. People live in fear. And all we're saying is it's time, 40 years into this epidemic, we're trying to end it. We have the tools and the strategies and the approaches to end it, that nobody should be on a sex registry by virtue of having a manageable illness. I think that they have done what they need to do to take care of themselves and the public's health. Nobody should have to live on a sex registry, not be able to go to schools, parent-teacher conferences, live next to a school, work next to a school. It really tears people's lives and affects them in many ways. I've heard people who've tried to commit suicide, post-traumatic stress disorder, depression, anxiety, because they've been on the sex registry for 14, 15, 16 years. I really hope that you can look at that and really make that change so people can live life with dignity and respect.
I mean, thank you for saying that. That's what I wanted to kind of get back to, if we could, because I know that's what the bill deals with now, is really folks that are on the violent sex offender registry. And I did take a minute, and members, if you've not actually gone on the sex offender registry and looked at it, it not only identifies what the conviction was for, it identifies the entire criminal history. It has a picture of the individual, their address. I mean, it's an enormous amount of information that is on there about folks. So, ma'am, I appreciate your advocacy for this. Again, I hope any ways that we can get to a point where this would be enough, that the criminal code would remain unchanged. I've stated that before. And really, I'm glad you articulated kind of the distinction on folks that do want to disclose. There's been very few of these cases that I've seen come through court. It's a pretty rare thing to see someone charged with this. But unfortunately, the cases I have seen fall on the other end of the spectrum on someone who has fallen into drug addiction and prostitution and really has fallen so far down in life that they literally have just given up and don't care. And then they expose others without disclosure, many times because, again, they themselves have been victimized and hurt, and they've just literally, they've just given up. And so, unfortunately, those circumstances, sometimes they will expose quite a few folks, but that's not the folks that I know necessarily that you're advocating for, even though we would all want to help those folks too come back up out of that just kind of despair. But thank you for your testimony today, and I appreciate you just allowing me a little bit of back and forth because I can't imagine the shoes that some of these folks have walked in and the paths they've tread, but I do think this bill would help some. Thank you.
Thank you. Appreciate it.
Thank you. Representative Griffey, brief comment.
Last comment. Thank you, Mr. Chairman. This is to legal, so there's clarity. Make no mistake. If we do this bill, someone that knowingly engages in this behavior and even transmitted HIV to somebody else, it will allow them to apply and come off the sexual offender registry.
Michelle Fogarty, Legal Services. If this bill as amended passes, someone who's convicted of this offense would not be required to register as a sex offender.
And if they previously have a conviction, they can apply to actually get off the sexual offender registry. And so future victims will have no idea about what this person has done in the past.
An offender who was required to register based on a conviction of this offense prior to July 1, 2022 can apply to the TBI to be removed, yes.
Representative Sexton.
Yes, I just wanted to clarify the reason that they got onto the registry to begin with was because that they knowingly had the disease and they passed it on to someone else without notifying them. Is that how they get on the registry?
Under current law, a person convicted of criminal exposure to HIV is required to register as a sex offender. And the elements of that offense are that they, knowing they are infected, they knowingly engage in intimate contact with another or in some way transfer the disease to another person.
Okay. Any other questions for legal? Representative Hardaway.
Thank you, Chairman. Counselor, is this offense that got any of the offenses that get you on the registry, are they expungible?
I don't believe this offense is expungible. And actually, as correction to Representative Sexton, you don't actually have to transmit the disease. You just have to either transfer, donate, or provide blood, tissue, semen, organs, or other infectious bodily fluids in any manner that presents a significant risk of HIV transmission.
And would that description include knowledge and intent, or just knowledge, or is that relevant?
It's knowingly. The person has to know that they're infected and knowingly engage in that behavior.
Okay, is there a difference in the current statute in knowing that they're currently infected and knowing that they're infectious?
The current statute just says knowing that the person is infected with HIV.
All right, and Mr. Chairman, this might go better to the sponsor. The intent of the legislation, is it geared towards individuals infected or those who are infectious, knowing that you're infected or knowing that you're infectious? And I asked that question with the caveat that even with the therapy, in my mind, if it's not 100%, you're still infected. You're just not infectious. And I may be given a different description than you would, but that's the way it is in my mind. The answer that you gave to Leader Lambert.
Representative Ramsey, do you want to respond to his question he directed to you?
Yeah, that portion of Tennessee code doesn't change, and the word is exposure. So if you know you're infected or if you know you're infectious and you expose somebody else, whether you give it to them or not, you are culpable in this Class C felony. All this amended bill does is say you got to serve your time. You have to observe whatever the court hands down as far as a verdict on that offense, but you don't have to go on the sex registry, the SOR. And our opinion is that this registry was put together 1996. It was intended to protect children. And I read off all these offenses here, all kinds of child murder and kidnapping. Those are the things that it intended to focus on, not this issue. So you're still culpable. You still have to abide by whatever the court declares that you did and finds you guilty of, but you don't have to go on the sexual offense registry.
Thank you, Chairman. Thank to both of y'all, and thank you, legal.
Thank you. Any other questions for our guest while we're out of session? Seeing none, we will go back into session. Thank you for your time. We're back on House Bill 1214 as amended. Any questions or comments for the sponsor? Seeing none, we're now voting to send House Bill 1214 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? No. No. The bill prevails. It will move on to full criminal.
Thank
you. Which should be recorded as a no. Please see the clerk. Put me as a no, please. Item number 14, House Bill 2427 by Chairman Lafferty. We're going to roll that to the Hill. Item number 15, House Bill 2583 by Representative Eldridge. We're going to roll that one without objection to the Hill. Item number 16, House Bill 2722 by Leader Love. Without objection, we'll roll 10 spaces. Item 17, House Bill 1968 by Representative Freeman. He was here. We will roll him 2 spaces. Item number 18, House Bill 1493 by Representative Towns. He has to roll this bill to the Hill? Okay. Without objection, we will roll House Bill 1493 to the Hill. That brings us back to item 17 by 1968 by Representative Freeman. He's not here, so we will roll him another. We'll roll him 2 spaces. Item 19, House Bill 2794 by Representative Johnson. You have a motion and a second. You are recognized. There are no amendments.
I have introduced House Bill 2794 to increase the security of Tennessee's children. We're all safer when guns are stored unloaded, locked, and separate from ammunition. One study found that households that locked both firearms and ammunition were associated with a 78% lower risk of self-inflicted firearm injuries and 85% lower risk of unintentional firearm injuries among children and teens compared to those that locked neither. Another estimated that if half of the households that with children have at least one unlocked gun switch to locking their guns, 1/3 of youth gun suicides and unintentional deaths could be prevented. And that's saving an estimated 250 lives a year. And it's estimated that 54% of gun owners do not lock their guns securely. In incidents of gunfire on school grounds, up to 80% of shooters under the age of 18 got the gun from their home or from the home of friends. In 2016, the Tennessee General Assembly heard legislation that would strengthen safekeeping of guns with the intent of keeping our children safe. It failed in committee, and since that legislation was heard in 2016, there have been 60 shootings involving minor children and unsecured firearms. 22 of these unintentional shootings were fatal, and in 12 of these shootings, toddlers were the ones shooting the guns. 40 of these shootings took place in the home. These kinds of shootings are very common in Tennessee. In fact, a joint study in 2017 found that Tennessee leads the country in shootings involving unsecured weapons and children. The only way to stop these fatalities and injuries is through strong child access prevention laws. Several peer-reviewed studies have found that strong cap laws are associated with a significant reduction in all pediatric firearm injuries, including those that are intentional and unintentional. These same studies found that weak cap laws are associated with an increased risk of all pediatric firearm injuries. There's no reason that a child should use a gun for purposes other than sporting activities. This bill, of course, excludes anyone who is being supervised by an approved adult or you do it for sporting activities. My nephew got his first deer at 12. He was supervised by his friend's father when they went hunting. So things like that obviously are excused. This bill is going to be an excellent way to keep children in Tennessee safe. Even the NRA believes in safe gun storage, and this just makes sure that we are following those rules, doing all we can to keep kids in Tennessee safe. We have the ability to save lives with the passing and implementation of this legislation, and I would love to see us do it. There's been legislation passed in many other southern states like ours. It's not anti-Second Amendment. It doesn't take guns away. It just makes sure that gun owners keep their guns safe. Also, I believe we have someone here that would like to testify on the bill.
Thank you for your explanation. Members, we do have some on the list. We will go out of session to hear from Kathy Barnett. You will have 4 minutes for testimony, and then if you will introduce yourself, you have 4 minutes for testimony. If you will make sure that your button is pushed there, I'm sorry.
Okay.
There you go.
It's on now? Okay. I do that every time. I'm Kathy Barnett. I represent Moms Demand Action for Gun Sense in America and Tennessee. We're a gun safety and gun violence prevention organization, and we support House Bill 2794 and ask you to vote yes. I'm going to repeat a lot of what the sponsor has said, but hopefully you'll listen. Firearms are the leading cause of death for children and teens in the United States. This is new. This has never happened before. Current Tennessee law prohibits a parent or guardian from giving a child or teenager a handgun if they think that minor child might commit a crime with it. This offense is a Class D felony. However, if they do provide a handgun to a juvenile, it's still a crime, a Class A misdemeanor. Though these laws are aimed at protecting children and encouraging responsible behavior, there's more that can be done. Here's how House Bill 2794 will help. It will penalize people who leave guns unsecured, easy for children under 12 years to find and do harm to themselves and others. However, House Bill 2794 will not apply when minor children have the permission of a parent or a guardian to possess the gun and are under adult supervision engaging in lawful activities such as a gun safety class. This raises the important issue of safe storage. Current research shows that more than half of gun owners fail to store all of their guns securely. Because of this, an estimated 4.6 million American children live in households with at least one unlocked and loaded gun. It is likely that these numbers have gone up during the past 2 years during the COVID-19 gun sales surge. The fact is that children die when adults don't secure their guns. Here at home in Tennessee in 2021, 9 children, including 3 2-year-olds and a 1-year-old, died by a gun because someone had not secured the gun. Another 5 children were shot but survived. These tragedies happened in Memphis, Martin, Cleveland, Clarksville, Nashville, Chattanooga, and Knoxville. Because even one death or injury is far too many, our organization researched whether gun storage policies and laws that prevent unintentional shootings. Here are the facts. 9 out of the 10 states where unintentional child shootings are rarest have a child access prevention law. In states with child access prevention laws, adolescents aged 14 to 17 saw an 8% decrease in total suicide rates and an 11% decrease in firearm suicide rates. The 10 states without such laws, states with the highest rates of unintentional child shootings are Louisiana, Alaska, Mississippi, Tennessee, Missouri, Alabama, Kentucky, South Carolina, Indiana, and Georgia. Laws that actually prevent unintentional child shootings take several forms. These laws can penalize those who fail to securely store guns when a child is likely to access a gun or when a child does actually get a hold of one. Because of this, laws like our own that punish an adult only when they recklessly give a child a gun apply in very narrow circumstances. It is clear it's not enough. We are 4th in the nation for unintentional child shootings. Why wouldn't we pass a child access law that works? One study found that households that locked both firearms and ammunition were associated with a 78% lower risk of self-inflicted firearm injuries and an 85% lower risk of unintentional firearm injuries among children compared to those that locked neither. We should be passing laws that require secure storage and prevent more deaths of children. Please vote yes for House Bill 2794.
All right, thank you for that. Any members you have questions for our guest? Representative Hardaway.
Thank you, Chairman, and thank you, ma'am, for being here this morning. Would you cite the numbers for suicide again for
Okay.
juvenile underage children?
Okay, let me see if I can find that. I don't have it memorized here, but let me see.
But you did state that the numbers
here it
have
is.
gone up.
It was the rates, the total suicide rates. There was an 8% decrease in total suicide rates for the states that had laws, child access prevention laws.
And those that did not, do you have those numbers?
I do not.
But you do have those numbers for the actual murders, shootings.
Right.
For states that don't have those.
The states that have the child access prevention laws, I have that there is an 8% decrease in suicide rates.
Okay.
Yes.
And it's something that sticks with me over the years from hearing testimony, and I think it may have originated from Moms Demand Action, for me anyway. And that's how young folks who attempt suicide and fail rarely try it again.
That's true.
But when they try it with a firearm, the success rate is usually 100%. So they don't have a chance to rethink their action. And that's one of the more jarring pieces of evidence that I have come upon since y'all have started. And It's just common sense legislation. It's data-driven legislation. It's evidence-based. It just makes sense to me what the sponsor is bringing to us for consideration. And I guess the irony is that yesterday, it's either yesterday or the day before, in Memphis, we lost the life of a 3-year-old who had an AR-15. Got hold of an AR-15, a 3-year-old, because the parents left it laying around and they went shopping or somewhere or the other. But that AR-15 could very well have killed several folks. A 3-year-old. So this bill makes sense. I thank the sponsor for bringing it. Mr. Chairman, I could talk all day on this, but I won't.
And I might add that it's not just the victim, the child, if they're shot and killed, it's their parents, it affects their siblings, their teachers, even the medical personnel that tried to save their life. So.
Thank you. Members, any other questions or comments for our guest? Seeing none, we will go back into session. We are back on House Bill 2794. Question has been called. Any objection? Seeing none. We're now voting on sending House Bill 2794 on the full criminal. All those in favor say aye. Aye. Those opposed? No. The noes prevail. The bill fails.
Thank you, Mr. Chairman and members.
Members, we are out of time for today. We are going to recess until 9 a.m. tomorrow morning.